So hello everyone, and warmly welcome to this webinar, The Crime of Ecocide Through a Human Rights Lens, a new tool for just transition. The relationship between human rights, climate change and environment is clear to all of us, I would say. And more people around us arrive there as well. But it has definitely not been discussed enough, and thereby the relation between human rights law and the crime of ecocide needs more attention. A report soon to be released, written by Kate Mackintosh and Lisa Oldring, will hopefully and probably be an important step forward in that process. My name is Martin Lindström. I've been on the board of End Ecocide Sweden for 7 years, mainly working with business issues in the business community. And I really look forward to learn more about this perspective that we're now looking into today. I have the pleasure to moderate this webinar, and I want to present our expert panel today. First of all, it's Kate Mackintosh and Lisa Oldring, who are co-authors of the report that we will hear much more about. Kate Mackintosh is the Executive Director of Promise Institute for Human Rights at UCLA School of Law. She has also worked a lot with and deeply with international crime, criminal justice and human rights. Also worth to mention is that she served as a deputy chair of the independent legal panel, which presented a legal definition of ecocide as a crime in 2021. Very much needed to have that definition. Lisa is both a legal advisor to Stop Ecocide Canada, and she is also currently a PhD candidate at the Grotius Center for International Legal Studies at Leiden University. Previously, she served as a senior advisor at the UN Human Rights Office. We will also meet two commentators. It's Susanne Sweet. Susanne is an associate professor at Stockholm School of Economics and is very deeply involved in CSR issues there and questions. We also will meet with Johan Hall, who is the research officer at LO Sweden. That's the Swedish Trade Union Confederation, also working on a European level on sustainability issues. The structure of today's webinar will be that Lisa and then Kate will present around their report and the work that they're doing together. Then we will listen to Susanne for 5 minutes, and then to Johan. They both will comment on the presentation by Lisa and Kate. After that, it's time for questions and answers. And just to make that clear, when you have a question, please write it into the Q&A. Please do not use the chat for questions, but use the Q&A, and we will pick them up and answer them as good as we can during the rest of the webinar. So again, warmly welcome, and I invite you, Lisa, to start.
Thank you so much, Martin, and sincere thanks to the organizers for the invitation to participate. I also have to say it's such a pleasure to be working with Kate on these issues, and hopefully today between the two of us we'll manage to cover the key issues that we've been working on together in the short time that we have available. And I really look forward to discussion because, you know, this is a work in progress, and I'm certainly learning as we move forward through it. So states have made a whole range of important commitments to the environment through legal and political frameworks. So why on earth are we talking about human rights and international criminal law in relation to environmental damage? In essence, international criminal law exists to protect against serious harm and ensure accountability. And as the statute of the International Criminal Court sets out, its purpose is to hold perpetrators of the most serious crimes of international concern to account and to help prevent such crimes from occurring. There are 4 crimes covered under the ICC statute currently: genocide, crimes against humanity, the crime of aggression, and war crimes. And we've heard a good deal about these crimes in the current context in relation to the Ukraine. But although war crimes includes one quite narrowly defined provision for the protection of the environment in times of international armed conflict, there's currently no international crime prohibiting acts that cause severe and either widespread or long-term damage to the environment outside of an armed conflict. And this despite the fact that such acts contribute to the climate and biodiversity crisis that we now face. The addition of a crime, an international crime of ecocide, would redress this accountability gap. And it would do so by establishing individual criminal responsibility for perpetrators of such harm, whether they're decision makers in government or in the corporate sphere. So in the few minutes that I have available, I'd like to address 2 points related to this. And the first is to highlight developments in human rights law and practice that I think help deepen our appreciation of the relationship between people and the environment, and how this really helps to underpin and shape ecocide as an international crime. And secondly, I'll address questions of corporate accountability and the potential of ecocide crime in this regard. So to the first point, human rights and environmental protection have largely evolved as separate systems with different standards and obligations. But there's a deepening appreciation of the interconnectivity between people and the environment. And with the ever worsening climate crisis, there are calls for greater accountability for harms to both. There's increasing pressure on states and on corporate actors to focus on protecting both people and the planet, and in doing so to satisfy their obligations in relation to both. The international human rights system, national human rights institutions, and courts at national and regional levels all have helped to sort of analyze these linkages and help clarify the responsibilities of states and non-state actors in relation to human rights and the environment. So for example, this past October, after many years of dedicated work by environmental defenders, human rights activists, Indigenous peoples, and many others, the UN Human Rights Council adopted a landmark resolution that recognizes the human right to a clean, healthy, and sustainable environment. So the resolution, it doesn't create binding legal obligations for states. It's what we refer to as soft law. But it does strengthen the place of environmental human rights at the international level. And it may also bolster some of the legal initiatives that are underway at national and international levels. There are an increasing number of cases in courts in countries around the world in which plaintiffs are using not only environmental law, but also human rights law alongside climate science as a source for innovative legal action against states and corporate actors. And it's interesting to note that an increasing proportion of these cases are being brought by young people on behalf of present and future generations. The Human Rights Council resolution acknowledges that environmental degradation, climate change, and unsustainable development are among the most serious threats to human rights of present and future generations. It highlights the grossly disproportionate impact of environmental damage on certain individuals and communities. And we know this sort of vicious cycle that worsens climate injustices, which is that the people who contribute least to the problem suffer its worst consequences. Just for example, all children are particularly vulnerable to the impacts of the climate crisis, but nearly half of the world's children live at extremely high risk in places where poverty and a lack of access to clean water, healthcare, and education intersect to diminish the likelihood of a child's ability to survive the climate crisis. A human rights lens also reveals the exclusion of individuals and communities that are deeply affected by environmental destruction from decision-making processes around climate solutions, and the profound impact this can have both on people's lives, but also on the effectiveness of the solutions for the planet. We know, for instance, that Indigenous peoples play an invaluable part in sustainable environmental management and biodiversity conservation in many areas of the world, and this was acknowledged in the latest IPCC report. Yet in many places, the voices of Indigenous peoples continue to be marginalized and even silenced. According to a Global Witness report, there were 227 environmental and land defenders killed in 2020 alone, and Indigenous peoples accounted for more than a third of that figure. So I think these human rights insights and developments, they're important because they reflect the interconnectivity of people and the environment, emphasizing the human dimension of environmental damage and destruction, and providing insights as to the grave impact of specific acts of ecocide on marginalized group in a way that sort of informs the nature of the crime. What we've seen also is that taken as a whole, they signal a demand for more ambitious policy responses to the climate crisis and environmental damage, and a desire on the part of people around the world for greater accountability for actions that cause harm to the environment and to human rights. And it's here that the need for an international crime of ecocide emerges. The second point I'd like to mention just briefly relates to corporate accountability. We know the guiding principles on business and human rights, which were endorsed by the UN Human Rights Council over 10 years ago now, set out a corporate responsibility to respect human rights and specifies what that means. It requires that businesses avoid causing or contributing to adverse human rights impacts through their own activities and to address these impacts when they do occur. The effective implementation of those principles can help protect the environment and those that depend on the environment and ensure access to justice and remedies when they do occur. And some businesses have recognized, for example, how due diligence policies can help them to identify, assess, prevent, and mitigate adverse environmental and human rights impacts. And some states have considered enacting legislations that would mandate corporate actors to take those measures. And there's a business case for this, since clear legislative boundaries can help level the playing field by establishing greater legal certainty around the standards expected of companies, and also ensure a measure of accountability when these standards are not met. So these are critically important measures, but on their own, they're not sufficient to prevent or redress the most serious harms. And in reality, corporate actors rarely have been held accountable for acts that have caused severe and widespread or long-term damage to the environment. We've seen in some large investment funds that are now leaning on firms to change the way they do business. For example, requiring companies to provide detailed explanations of how they intend to meet environmental and human rights goals. And the International Corporate Governance Network recently went further in its statement to the climate conference in Glasgow last fall, when it called on governments and standard setters to take a wide range of measures, including, quote, to collaborate internationally to criminalize ecocide. The establishment of an international crime of ecocide, I think, would align with these corporate and investor-driven demands for greater human rights and environmental accountability. It would also push states to take effective legislative action at domestic level. And crucially, it would hold individual corporate actors internationally accountable in ways that the human rights framework alone cannot. At the same time, the responsibility of corporations to carry out human rights due diligence as mapped by the UN Guiding Principles, can help sort of flesh out elements of the proposed crime of ecocide. And perhaps most importantly, they could help make an international crime of ecocide an enforceable deterrent by influencing decision-making processes across sectors where there's potential for serious harm. After all, our most pressing objective is one of prevention. And going back 50 years, as Olof Palme set out in his visionary statement, the far-reaching changes in attitudes and social structures that we urgently need. I'll stop here and turn to Kate, and thanks very much for your time.
Thanks very much, Lisa. Kate, please.
Thank you, and thanks, Lisa. And I have to say, it's great working with Lisa as well. So I want to just build off what Lisa's been talking about by talking about two other aspects of the relationship between ecocide and human rights. And the first is how the crime of ecocide, at least as we've proposed it, complements human rights by going beyond anthropocentrism. And the second is about how human rights can help ecocide prosecutions achieve environmental and climate justice. And I'll explain what I mean by that a bit more in a moment. So as I said, when I speak about ecocide, I am talking about the definition that the panel proposed in June, and I'm just posting a link to that in the chat in case anyone wants to look at the definition. So as some of you may know, and as was mentioned by Martin in his introduction last June, a panel which I was part of, which is chaired by Philippe Sands and Dior Falsao, proposed a definition of the crime of ecocide to be incorporated into the International Criminal Court statute as a fifth crime. So that's what I'm referring to when I talk about ecocide. So Lisa did a great job of outlining how human rights law now, pretty firmly recognises that harm to the environment impacts human rights, and that's at the foundation of introducing a new crime of ecocide. So it's hugely important in a number of ways, but also brings with it some potential for blind spots, because a human rights approach obviously puts humans at its centre. And what does this mean for the protection of the environment? Well, even though we may understand at some level that our interconnection between humans and the environment means that any environmental harm is a harm to humans, it is harder for a strictly human rights approach to address environmental harms whose effect on people is either not immediately apparent or perhaps unknown. So the definition of ecocide could be seen to complement the human rights approach in that we did not include any requirement for human harm in the crime. So the crime can be committed without any harm to humans being demonstrated. The elements of the environment are included as protected values per se. So turning to the definition briefly, our actual definition is quite short, but then we have a lot of definitions of the terms after that, which make it a bit longer. But the threshold we use, the gravity threshold for harm to the environment to reach the level of an international crime, is that it would be severe, has to be severe, and then either widespread or long-term. And in the definition of severe, we talk about damage which involves very serious adverse changes, disruption or harm to any element of the environment, including grave impacts on human life or on natural, cultural or economic resources. So impacts on human life, of course, are hugely important and are in there, but they are not the only way in which severity can be assessed, and the damage has to be severe for it to reach the level of a crime of ecocide. And the other relevant definition is around widespread. So damage has to be severe and either long-term or widespread. Well, the long-term definition has no impact, does not relate to humans at all. The widespread definition covers both, the human and non-human impacts. So we defined widespread as damage which extends beyond a limited geographical area, crosses state boundaries, fair enough, or is suffered by an entire ecosystem or species or a large number of human beings. So the definition was very much informed by a wish actually to dissolve the division between anthropocentric and ecocentric. And we actually think the crime of ecocide is an expression of the understanding that that is a false division. So while ecocide, as we've said, expresses the interrelationship of human rights and the environment, it also could be seen to complement the human rights approach in some ways, and perhaps even show a way forward for human rights. And let's see how that develops by moving beyond pure anthropocentrism. The human rights approach, on the other hand, offers a lot to the crime of ecocide, and that's what I'd like to talk about next. And Lisa's already talked about how a human rights analysis can highlight who is the victim of the crimes, reveal the human stories beyond the environmental destruction, look at who is affected, and in particular, are all people affected equally? And the answer, of course, is no. And Lisa's already talked about a number of those impacts. I could also mention the gendered impact, which we know that environmental damage is having with women and girls suffering disproportionately from the impacts of climate breakdown. Lisa's talked about the particular impact on Indigenous people, but a racialized analysis also demonstrates how not only Indigenous peoples, but people of African descent, and also within particular countries, marginalized groups, people living in poverty, who often are people who are racialized in some way. And I'm thinking of, I live in the United States, where the systemic racism here is so clear. And the groups that are suffering the most environmental harms will tend to be groups which are racialized, seen in some way. So the human rights analysis does that, and it does that through a number of things. It does that because there are specific protections for different groups in the human rights system. So the human rights system flags that we need to pay attention to, for example, Indigenous people, children, women. It also flags the very important core prohibition on discrimination. So discrimination under human rights law does not have to be intentionally carried out. There doesn't have to be an intention to discriminate. Human rights law is concerned with preventing actions which result in a discriminatory impact. So taking that spirit into the prosecution of ecocide law will mean looking for the kind of disparate impacts that Lisa and I have been outlining. And this will be hugely important in terms of building a body of protected law through the use of this ecocide crime. And to explain what I mean by that, I want to analogize what happened around the prosecution of sexual and gender-based violence at the international criminal courts that were set up to prosecute crimes in Rwanda and Yugoslavia, and also has continued to be an issue at the International Criminal Court. So what happened in those early prosecutions? So those were the first situations where international crimes were prosecuted at an international level since Nuremberg. And of course, international crimes provide for, of course, they prohibit sexual violence. I mean, they prohibit torture and ill treatment. And of course, sexual violence falls into that category. But some very important steps at the beginning of these prosecutions were taken by prosecutors and judges, because the initial indictments did not specifically allege sexual violence. So they used the umbrella terms of torture, mistreatment, and so on. And within that, they would be presenting witness evidence or evidence of sexual and gender-based violence having been committed in the conflict. And a number really of feminist activists who were working in the court, including the president of the Rwanda tribunal, Nadi Pillay, who presided over the first case at the Rwanda tribunal, she actually sent the indictment, the initial indictment she received, back to the prosecutor and insisted that they specifically charge the sexual and gender-based violence. And this started a practice which slowly grew through the Rwanda and Yugoslavia tribunal of explicitly charging sexual and gender-based violence. The impact of that is that the judgments, if the prosecution manages to establish its case, the judgments will include findings on sexual and gender-based violence. And that crime will begin to be delineated in ways that makes it much more impactful as a deterrent. And also, of course, means that it tells the story more accurately of what happened during those conflicts. And now we see those crimes were much more clearly articulated in the International Criminal Court statute, and there is a push to make sure that all of those crimes are investigated, first of all, and then prosecuted where they're taking place. So switching back to the crime of ecocide, the human rights lens, which we've talked about, which highlights the disparate impact on groups, which highlights how the vulnerable are suffering from environmental destruction and climate change. If the human rights lens is brought to that, if that is taken into the indictments, we will see the crime of ecocide being used to write the story of this disparate impact. And that is a step towards writing that situation. So we will see jurisprudence coming out which highlights that that's happening and which highlights that that's prohibited and which can be used as deterrent in future situations. So I would say that using the human rights lens to reveal those stories, those human stories, those disparate impacts, helping prosecutors to frame their indictments to reflect the full impact of the criminality is a really important step towards building environmental and climate justice. Thank you.
Thank you very much, Kate, and again, Lisa and Kate, for this presentation. So interesting, and I see now that on the Q&A there are questions coming in, but we'll leave them for a little bit and listen to Susanne first on commenting on this. Thank you.
Yes, thank you very much. And also thank you, Lisa and Kate, for an interesting both report that I've sort of sneak peeked at, and also your presentation. I think this relationship is very interesting in many ways. The research I'm doing, for instance, it's more and more common that people sort of link environmental and social issues together, because there is sometimes no boundaries. It's very hard to see the boundaries, or they affect each other in both ways, in different ways. So thank you for also bringing this up in a good way, also from law and that perspective. I'm at the business school, I could say, so I work on corporate sustainability and responsibility issues, both research and teach those things. So that's from the perspective I come from. The 1948 human rights came about also because of, I would say, almost like a worldwide moral crisis. It was deeply felt, the wrongdoings that was done during World War II. And so I just have like a reflection. So can we get this sense of deep moral wrongdoing that is happening in crimes to the environment, i.e., and can we call them crimes, because maybe it's not even defined as crimes in law, neither on the national level or international level. We have lots of different policy arguments, we have different frameworks, etc., etc. But can we call it a crime? That's like a reflection I have. And do we, as the Earth's human population, feel and share this idea that actually this is a crime if we continue to eradicate species, if we continue not to take the climate impact seriously, etc. Can we, as a human, feel the same outrage? Can we get there? It's sort of a reflection that I have, that, and maybe a question mark, that what does it take for us to come to the point as they were after World War II, when they developed human rights law internationally. So that's sort of just some basic, is this a moral crisis in the same way? And can we reach there? And maybe also in the backlight of that, we, in spite of having this human rights and international law, the cases that are maybe not as severe as they would be in a war situation have we really come to grips with all the violations that are ongoing? And can we sort of transfer that also and include it when it comes to environmental damage and crimes that we do? So that's a reflection, because I think if we can reach that on some level, maybe there is hope to create something international and integrated with the human rights, or have it as a freestanding, that the protecting the environment is indeed something that is of same severity and greenness as the human rights violations. So that's a sort of a beginning. And then I had some more maybe specific things like the interlinkages between human rights and protection of environment, or crimes against the environment. I think it's there. It's very clearly also when you go down and look at very specific cases on different sectors. I myself have studied the fashion industry and the textile industry, very globalized industry with many issues around both environment and social issues. And you can clearly see on a very also local level, although it's international trade. So therefore the boundary issue around, does it need to cross, national boundaries? Well, if the trade is there, if we buy things that are manufactured somewhere else, does that count in? And in the fashion industry, textile industry, you can just see the factories that are burn. I mean, they use energy from coal base, so the climate impact is pretty severe. So 80% of the climate impact from the industry comes from factories in the manufacturing phase, because of the coal-fueled factories. Lots of chemicals are used, lots of water is used, and also there's no cleaning technology. We sort of damage the environment very locally around factories, but that will influence not only the workers in terms of health and working conditions, but also the community surviving around those factories, which more often than not are placed in low-income countries.
Okay.
Of course. So that is, and then these different levels, so the boundaries, international, national, corporate, individual, which also links to the Sustainable Development Goals, and how we sort of interlink with them, where we have lots of research showing that it's both, win-wins by working together. So human rights, or facing on the rights of humans and the environment together, might have win-win, but it also built in conflicts and trade-offs. And also there, we can see that those trade-offs are greatest in less developed countries, or where they're more vulnerable communities. So again, these are things to, I guess, take into consideration. But I think it's great also that you pointed to that there are lots of research showing these linkages now, specifically on harming the environment and what kind of human rights impacts that will have. So I think that is fantastic if we can sort of build that research. Thank you.
Thank you very much, Susanne. And Johan, please.
Yeah, thank you very much. And thank you very much, Lisa and Kate, for an interesting report. I had the possibility to read your draft here, and I found it very interesting. I come from the trade union, and one of the basic ideas of the labor movement is that we ourselves as human beings can create a better future through our work. At the same time, we can see that certain production and certain goods and services actually put our future at stake. They can threaten biodiversity or cause global temperatures to rise and climate change. And I think that when nature is perceived as a free and infinite resource, and technology is seen as an opportunity for people to use nature to increase economic growth, we risk working contrary to our real goals. It's even worse, I'd say, because of the often narrow-mindedness that makes economic growth perceived as the same as improved living conditions. I think it's necessary to broaden our perspective in order to find a working balance between economic growth and sustainable local and global environment. Nature is not infinite, and human welfare is not decoupled from the well-being of nature. And it becomes obvious when, as Kate and Lisa writes in their paper, even conservative estimates suggest that without urgent action, the climate crisis will push 120 million more people into poverty by 2030. And if ecocide occurs, it doesn't matter how much we work or how big the economic growth is. For the people who live there, the living conditions will be worse, which is the opposite of the basic idea and purpose of the labor movement, which is to create a better future. I think, therefore, we need a law to guarantee people to live a decent life in line with the ecological boundaries. And that's why I think it's also important for the unions to discuss this issue about ecocide and how it can help improve the conditions in line with our ideas about a better future and how work can be in line with the ecologic boundaries. Thank you.
Thank you so much, Johan, and all of you. We do now have a number of questions, and there are a number of questions, and I think we'll treat them as panel questions. So the one of you who wants to answers, and if there is another perspective, that's most welcome as well. I'll read it out loud, and the one of you who wants to answer the question, please do. The first question is from Oliver. He says, super interesting event, thank you. The question is, despite the ability for ecocide and human rights to complement each other, are there any potential tensions or antagonistic relations between them? This could be in practice or theoretical, ontological, that's a word, epistemological, etc.
I can start by just saying that the tension that we might think about is the tension that I referred to earlier, which is that human rights is focused on humans. And that's not necessarily the best approach for protecting the environment, although the whole point of our paper, really, most of it, is to show how a human rights approach can actually improve our understanding and protection of the environment. But there is some kind of theoretical tension there. I mean, it's like, the interesting developments around rights of nature. I often think, where rivers have been granted independent legal rights in a couple of jurisdictions, actually in Northern California, is not as well known maybe as the one in Ecuador and I think New Zealand, right? But I sometimes think about, well, what does that mean for human rights, the rights of nature, and how does human rights as a framework cope with that? I mean, it seems like a good thing. And I wonder whether, and that's what I was gesturing towards when I was speaking, I wonder if human rights can somehow expand its thinking to go beyond the human without that being a complete contradiction in terms. I mean, the Inter-American Court for Human Rights has made some, which is probably the most progressive human rights system in terms of protection of the environment. The Inter-American Court has made some really interesting pronouncements which seem to recognize, or at least go in the direction of rights of nature, which is interesting in a system which normally centers humans. So I think there's some really, potentially productive, creative tension there.
Anyone else who wants to add something to that? Thank you, Kate. Wonderful. The next question is from Maria, and she says, do you think that the Chevron Texaco case from Ecuador can be a good example for ecocide?
Lisa?
I mean, just to sort of the elephant in the room is that I think that lawyers are traditionally very hesitant to talk about specific cases in an abstract way. So it's I tend to sort of prefer to talk about notion of ecocide and the legal issues around it, rather than specific instance, commenting on specific instances. Also, because we're talking about international criminal law, and specifically the addition of ecocide as a crime to the statute of the International Criminal Court, which operates, that there's this principle of non-retroactivity. So if there was to be an amendment to include ecocide as a crime, you wouldn't be looking back to situations that have happened in the past. And Kate might want to complement that. There might be a situation that began in the past and that's ongoing at the time that the crime is recognized. But yeah, I'll turn that hot potato over to you, Kate.
Yeah, I would say look at the definition. I mean, I would say to the person who raised the question, look at the definition. I mean, there's no like jurisprudence, or there are no decisions of courts that you need to know about in order to interpret this definition, because it doesn't exist yet, right? So it's literally those words on the paper. So I think anybody is equally capable of making their own judgment about whether a situation falls into that definition or not. We've crafted, we've put the words down, and we very much hope that soon judges will be applying that to real life situations. But I would answer the question by saying just have a look at the definition and see whether you think it falls within it.
So maybe I can jump in, because I mean, in the CSR or corporate responsibility kind of tradition, I think you can go in and say that, okay, this is sort of hideous, and who bears the responsibility. And when there are big accidents like oil spills and things like that, usually there is a lot of stakeholders involved in sort of setting the responsibilities, which you could see there is a need for some jurisdictional kind of boundary definition on who takes responsibility there, because then you have you have the insurance companies, you have the companies, and you have maybe those that own part of the output from the company. There is so many, it's very complex. So there is really I would say that when it comes to big accidents there is this need to have some sort of judicial system that actually can take it into account. So even if it's not a threat to humanity, it might be the consequences might be very local, but it's part of a global system. So I'm just, and the actors that you might point to have a responsibility are global actors. So here, I mean, I'm thinking also maybe ecocide, and you, Lisa and Kate might have a different view on this, but there are things that might not fall into, this is not threatening the planet consequence, but it's threatening definitely a region or the living conditions of many, even if it's contained in one country. So how would that sort of be treated?
Well, I can go back to the definition for all of that. So there is a clear, the idea would not be that it would be so very difficult to find responsibility, right? So we've defined it as unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And we've defined severe, widespread and long-term, as I said earlier. So an individual would have, through that person's own acts, they would have to be a substantial risk from that individual's acts of severe and either widespread or long-term, which is a high threshold. So it has to be somebody at a position of considerable influence. Someone who could take a decision which would unleash actions which would have the substantial likelihood of causing those harms, for example. So anybody that fell within that definition could potentially be liable for ecocide, as long as those acts were also unlawful or wanton. That's our other threshold. And there are, it's, although we're talking about very complex situations sometimes, international criminal law is used to dealing with complex crimes. So the kind of people who are brought to the International Criminal Court or the other international criminal courts that have existed, if we think about something like a crime against humanity, which has involved massive deportation and killing and ill treatment of people, for example, the people who are brought are not, or not generally, the individuals on the ground who've actually been committing the crime, the people who are actually shooting, etc., etc. That's not who the International Criminal Court is looking for. It's looking for the people higher up. And that's complex, drawing that web of accountability, but that's being done. So there are models to draw on for individual criminal responsibility for people in leadership positions. So it's, there is a solid body of legal precedent that can be used to attribute fault in these situations. And just the other thing I would say was, of course, if it's actually an accident, then there is no criminal liability, right? So somebody would have to know that through their acts there was a substantial likelihood of severe and either widespread or long-term damage to the environment being carried out. So the intent there, there is an intent. You do have to have knowledge, that standard knowledge of that risk. So if it's an accident, which isn't really an accident because people know that it's really very likely to happen, then that might fall into the category of ecocide. If it's a genuine unforeseeable accident, that's not a crime. So just to go back to Ecuador, because someone's saying what happened in Ecuador, etc. I mean, I'm happy to say that what happened in Ecuador looks like ecocide to me. We're talking about massive, massive pollution of, part of the Amazon as a result of oil extraction and processing, which is just absolutely horrific in terms of the impact that it's had on people's lives and is still having an impact on people's lives and has been the subject of very long litigation. And you can read all about it in many books that have been written about it. But I think, just, from what I know of that situation, and of course this is no legal definition, but from what I know about it, having read some of those books and looking at a definition, that looks like ecocide to me.
And it was not an accident, I would like to add to that.
It was most certainly not an accident. It was a very deliberate series. It was a project to extract the oil and deliberately to store the waste or not store the waste in certain ways and so on.
Right. Thanks very much, Kate. We'll go on with a couple of questions more. Thomas Nordberg has asked a lot of questions. That's a good occasion for me to say that we and Ecocide Sweden and Stop Ecocide and other organizations will be very active in the Stockholm Plus 50 conference coming up in 3 weeks. So that's a good place to get all the answers. To know a little bit more about that, go into endecocide.se and you will find many answers there. But I'll take one or two of Thomas' questions. How to prove intention for the destruction of a territory? Tough question. Anyone who wants to answer it?
I feel like I'm talking too much, but I'm happy to answer that. So the intent is So I think it's a really important point, actually, and thanks for asking that, Thomas, because of course most of the situations which we might think of as ecocide, and we might look at Ecuador, and we might all have other situations in mind, it's not like the motive of the action is to destroy the environment, right? I mean, there might be situations where that might happen, for example, in armed conflict, where there actually is, like the use of napalm in the Vietnam War. The intention is actually to destroy the environment in order that, you know, people can't hide, etc., or whatever other reasons they might have had. But this kind of industrial ecocide, for example, that we're talking about, that's not the intention to destroy the environment. The intention is, you know, probably some kind of financial gain, etc., It's a byproduct, but that isn't required. That isn't required. An intent to destroy the environment itself isn't required. Of course, the actual acts have to be done intentionally, but there's not an issue of some sort of motive behind that. That's not relevant to the crime. What is relevant to the crime, what the actual intent standard is knowledge that there's a substantial likelihood of severe and either widespread or long-term damage being caused by your acts. So that is the standard, and that is a legitimate standard in international criminal law. That is an acceptable intent standard. You don't have to intend to actually cause the damage. In our proposal, you just have to have knowledge that there's a substantial likelihood of that damage being caused.
Thank you. Next question is from Caroline. She asks, where are we at in terms of getting closer to actually get states to sign for an ecocide law and implement it?
I can maybe start to respond to that one, Martin. It's a great question. I joined this work just over a year ago, about a year and a half ago now, and already at that time, there was a palpable sense that this movement had sort of picked up quite a lot of speed in a very short amount of time. And I think the release of the definition by the independent expert panel last June really helped propel the discussion forward, because it sort of put something concrete in place for states to discuss and consider and actually see. And if you read the definition, you really can see how it draws on, it's grounded in existing international law. It builds on international legal principles, and it sort of is crafted in a way that finds its place, I think, neatly in the Rome Statute of the International Criminal Court. So I think that has really helped to sort of push developments forward. And you do see an increasing number of states expressing either clear support or interest in being more engaged in the discussion. So it's now kind of a critical time leading up to the annual Assembly of States Parties of the International Criminal Court coming up at the end of this year. And I think that it will be interesting to see whether one or more states will step forward and actually formally place the discussion on the agenda of the Assembly of States Parties. So I don't know whether, Kate, you want to pick up from there and add to that.
No, I think that's a pretty good description of where we are.
You can find, just to point people to the website of Stop Ecocide International, there's a list of supporting states with specific language around, you know, there are states that fall within a range of support again, and you can find that in the chat link. Louise Romain has just added the link.
Thank you very much. There is one question just came in, and I read it from there. There was a point made about knowledge. If you do not know that an action will lead to ecocide, then you cannot be held to account for crime. A problem I see all over is an ignorance to the science of climate change and environmental destruction. What is the baseline for basic knowledge? How can we avoid someone claiming ignorance to consequences of the decisions and actions?
Yeah, that's a great question as well. Thanks. So I think there are two points to respond to that. One is about whether, if somebody just says, oh, I didn't know, like it might be general knowledge, but I just personally, I don't read that stuff. Like I've never had that conversation, I don't know, kind of thing. And there's a limit to how far you get with that, basically. You know, it is possible for judges to infer that you had knowledge if it's a matter of, you know, general knowledge, or if through your work practices and the kind of information you've been exposed to, it seems that you actually did. So that's an evidentiary question. But it doesn't stop with somebody saying, oh, I personally didn't know. But I think what Jennifer's also pointing to is, you know, an interesting question about certainty of causation, and actually the state of the science, and the fact that it's not necessarily possible to prove 100% in all cases that these actions caused this environmental damage. I mean, in some cases it is, you know, I can imagine, like if there's an oil spill, you know, it's pretty straightforward to see that that oil has caused, you know, some immediate effects. But I think even in the Ecuador case, actually, there's some interesting issues of causation. But we dealt with that in our definition by requiring, we don't actually require your acts to have caused the damage. If you look carefully at the definition, and that's precisely because of this, well, it's a number of reasons, but one of them is this issue of, you know, the state of the science, that it might not actually be possible to prove. It might be, you might be able to show that it's very likely that it caused that these actions caused these results, but you may not be able to prove 100% with the state of the current science. And so we actually say that the acts have to be committed with knowledge of the substantial likelihood of that harm occurring, right? That's the threshold. It's actually not a crime of result, it's a crime of endangerment, as we call it. So it's about creating a risky environment. It's about creating a risk. That's the criminal act. And the risk is that there's a substantial likelihood. And our advice was that that was a reasonable standard in the state of the current science, like proving that there's a substantial likelihood, you know, is something that's achievable. And it also seemed to be reasonable in terms of criminal law. In other words, it's something that you can reasonably expect somebody to be aware of themselves. So that's another thing to see about the crime. If you look at it, it also doesn't wait for the acts to occur. You don't have to wait for that damage to manifest before this crime has been committed. The crime is a crime of endangerment, a crime of carrying out acts with the knowledge that you have created a substantial risk of this harm coming about.
I was just thinking about the similarities to OECD guidelines that for multinational companies that are also sort of, you can take a national stakeholder group that actually can take your companies for responsibility, and there is like this demand that also relating to this knowledge or not, that if they have also neglected to, for instance, implement safety standards, or if they've neglected to review security things on equipment, or I mean, in the oil spill, it was, do you have like double hull or not, or have the damage, or those that are reviewing and have to send in reports, have they failed somehow? So there is this like building a case where, I mean, that you cannot really escape the knowledge part. I mean, it's not that are you aware of that you could crash, but they should be aware of all these standard procedures that are anyway should be in place, because you need to report on them. And if you have a corrupted report, then yeah, somehow you can bind the responsibility to certain actors.
Thank you, Susanne. I break in because we need to finalize this webinar. It's 6 o'clock, and thank you all participants, and thank you so much for all the questions. We missed 2 of them, I know, but they were partly answered in other in other answers. And thank you so much, Johan, Kate, Lisa, and Susanne for your input and for your valuable expertise in this field. And hope to see you all in Stockholm Plus 50. There will be both digital and a lot of physical events that we will be in. Thank you very much.
Thanks, Martin.
Thanks, Martin.